Again, proceed with caution. If you're in doubt about whether it's a Fair Debt Collection Practices Act case or not, do the Fair Debt Collection Practices demand letter and treat it as a Fair Debt Collection Practices Act case. Always put in your mini Miranda. This may be, this communication is from a debt collector. Any information used will be obtained will be used for that purpose. Doesn't take too long. Okay, there are certain things that are allowed under the Fair Debt Collection Practices Act. Validation of debts, proper venue for suits, location information, if you're seeking information from a third party. So if you're seeking information from a third party, an employer or someone, you've got to clearly identify yourself, state that you're confirming or correcting location information concerning the consumer, and identify your employer if you're doing it. Not state that the consumer owes any debt, and not communicate with any such person more than once unless requested to do so by such person or unless the debt collector reasonably believes that the earlier response is wrong. Can't communicate by postcard because you're alerting the world that there is a debt collection matter. Don't use any language or symbol on any envelope or in the contents of any communication that indicates the debt collector is in the debt collection business. If your business is debts are us, you cannot put that on an envelope. There are certain things that you just can't do when we're talking about debt collection under the Fair Debt Collection Practices Act. Okay, if a consumer is represented by counsel and you know it or have reason to know it, you need to cease communications with the consumer. Okay, this usually breaks up talking about permitted activities under the Fair Debt Collection Practices Act. I'm going to just speed up. I normally do this all in one demand letter. The amount of the debt, name of the creditor, and that they have 30 days to dispute the validity of the debt or any portion thereof.